Good afternoon, guys. Let's discuss statute of frauds in relation to unenforceable contracts. Well, we already discussed unenforceable contracts. Number two is those that do not comply with the statute of frauds. So let's now discuss statute of frauds. Statute of frauds requires certain contracts to be in certain forms for it to be enforceable, for it to be valid, or for purposes of convenience. Okay. So, but you need to take note that statute of fraud only applies to executory contract. It does not apply when the contract is already partially executed. Okay. So, the statute of fraud requires the following contracts to be in writing for it to be enforceable, for purposes of enforceability. So, number one, an agreement that by its terms is not to be performed within 1 year from the making thereof. So, let's say, for example, I hire a building contractor to construct my mansion. The construction will commence 1 year after today. Okay. And it was made orally. Can the building contractor enforce the contract? The answer is no. Because that contract was made orally, and the statute of frauds requires that it should be in writing for it to be enforceable. Number two, a special promise to answer for the debts, default, or miscarriage of another, or what we call the contract of guarantee. So, let's say, for example, you wanted to apply for a loan with BPI, and BPI said, I need somebody to guarantee you that in case of default of payment from you, we can run after that somebody who is a guarantor. So then you come to me and said, sir, can you be the guarantor of my bank loan? Then I said, yes. So we both go to BPI, and I orally made myself liable for your default of payment for your bank loan. So then you defaulted your payment. Can BPI run after me and enforce the contract? The answer is no, because the contract of guarantee that I made was made orally, and the statute of fraud requires that it should be in writing for it to be enforceable. Okay. An agreement, the third one is an agreement in consideration of marriage other than mutual promise to marry. Okay. So, let's say, for example, I have been single for 40 years and my father is already worried that I will not get married. Then I finally said to him at the age of 41 that I will be getting married. So my father, because of happiness, orally promised to give me the condominium unit in Makati City. So then I get married. Can I enforce the promise made by my father to give me the condominium unit in Makati City? The answer is no, because that promise in consideration of marriage is made orally. So the statute of fraud requires that it should be in writing for it to be enforceable. What if, for example, you and your girlfriend or you and your boyfriend promise to each other to get married after 5 years? Does the law requires it to be in writing for it to be enforceable? The answer is no. Okay. The answer is no. The law does not require it to be in writing for it to be enforceable, because the third, what is only required to be in writing under number 3 is an agreement in consideration of marriage other than mutual promise to marry. So a mutual promise to marry can be made orally. Okay. Sale of goods, chattels, or things in action at a price not less than 500. So let's say, for example, a contract of sale was made by me and you selling my Samsung Galaxy Note 8 for a price of 5,000 pesos. So the law said it must be in writing for it to be enforceable. So if our contract of sale of the Samsung Galaxy Note 8 is made orally, then that contract is unenforceable under the Statute of Frauds. Okay. However, let's say for example, we have a contract of sale that is made orally selling my Samsung Galaxy Note 8 for a price of 5,000 and you have already paid 2,000 and I make an acknowledgement receipt stating that I acknowledge receipt the amount of 2,000 as a down payment for the sale. Then can you enforce the contract that is made orally? The answer is yes, because this time, though the contract is not in writing and the statute of frauds provide that it must be in writing to be enforceable, you need to remember that the statute of fraud is only applicable to executory contract. Now, because a down payment was already made, acknowledgement receipt was already given to you, then it's no longer executory contract. It's now considered to be a partially executed contract. And you need to take note that, guys, that statute of frauds does not apply to partially executed contracts. Okay, number 5. An agreement for the leasing of a real property or of an interest therein for more than 1 year. So let's say, for example, I have a parcel of land in the heart of the city. You wanted to rent it or lease it for 5 years. Then I said, go ahead, lease it for 5 years. And I said it orally. So it was not made in writing. So the contract, therefore, is unenforceable because the statute of fraud requires it to be in writing for it to be enforceable. But let's say, for example, you have already made 2 months advance lease for that property, and the lease is contract of lease was made orally. Can you enforce the contract now? The answer is yes, because the contract now is considered to be partially executed since you have already made 2 lease payment in advance. Okay. Number 6, sale of real property or interest therein regardless of the price. So let's say, for example, a contract of sale of a parcel of land that is located in the heart of the city was made orally. So, question, can you enforce the contract? The answer is no, because the statute of fraud requires that it must be in writing for it to be enforceable. However, you need to take note, guys, that if you have already made a down payment, of course, the contract is no longer to be executed or executory. The contract now is considered to be partially executed. Therefore, the statute of frauds, the requirements that it must be in writing will no longer apply. The last one, the last contract that should be in writing for purposes of enforceability of the contract is representation as to the credit of a third person. So let's say, for example, I went to the bank, sit in the front desk of the bank manager, and here comes you asking for the granting of loan in the bank, and the bank manager said, I don't know you, but I said to the bank manager na, well, I know him and he has a lot of businesses surrounding the city. So because of that representation, the bank manager granted the loan. Now you defaulted in your payment. Can the bank manager run after me because of that representation? The answer is no. Because my representation was made orally, and under the statute of fraud, the representation as to the credit of a third person must be in writing for it to be enforceable. Okay, so those are the contract, guys, that should be in writing for it to be enforceable. In addition to that, the statute of fraud requires the following contracts to be in certain forms for purposes of validity, which simply means that if the following contracts are not in its required formalities, the contract becomes void. Alright? So what are these contracts? Um, Contract of donation of an immovable must be in public document for it to be valid. So if it is only in writing, it's not notarized, so therefore it's the document is not a public document. It's considered to be a private document. Then that contract of donation that is in private document is not valid. Alright? Because the statute of fraud requires that it should be in public document for purposes of validity. So the second one is the contract of donation of personal property whose value is more than 5,000. So let's say, for example, I promise to donate to you my Samsung Galaxy Note 8, and it was made orally when the statute of fraud requires that it must be in writing for it to be valid. Then that contract of donation is void because it is not in its required formalities under the statute of frauds. Number 3, the authority of the agent to sell a piece of land must be in writing. Okay, so if the authority of the agent to sell a piece of land is only made orally, then that authority of the agent is void. Okay. The fourth one is the contract of partnership where an immovable is contributed must be in public document. So if the contract of partnership where an immovable is contributed is only made in writing, then that contract is void. Okay, right? In addition, further, the statute of frauds provides the following contracts must be in public document for purposes of convenience of recording in the respective recording office of the government. So what are these? Acts or contracts which has for its object the creation, transmission, modification, or extinguishment of real rights over immovable property. So what is an example of this? A last will and testament that is notarized. So the law requires that it should be notarized for purposes of convenience, for the effectivity of the last will and testament. Number 2, the cession, repudiation, or renunciation of hereditary rights or of those of conjugal partnership of gains. So let's say, for example, you are one of the heirs of your father, and you are already financially free. You are now rich, so you don't want money anymore. So you renounce your hereditary right. The law said you must have to put it in writing for purposes of convenience of recording. Okay. The power to administer property or any other power which has for its object an act appearing or which should appear in public document or should prejudice a third person. So let's say, for example, a power of attorney. I have been in the US for 20 years and I have properties in the Philippines, and I decided to sell the properties in the Philippines. So I asked my brother to represent me as a seller, as my agent. Okay. So the authority of my brother must be in writing, okay, or must be in public document. So the power of attorney must be in public document because the statute of fraud requires that it should be in public document. Okay. Number 4, the cession of actions or rights proceeding from an act appearing in public document. So I execute a public document making my brother as my legal representative or legal agent in the sale of my property. For me to take away that that authority to sell, I need to execute another contract in public document, ceasing or stopping or extinguishing the authority of my brother as my legal agent. So these are the situation, guys, that are required to be under that are required to be in public document under the Statute of Frauds for purposes of convenience of recording in the respective recording office in the government. So, bye guys!